Welcome to our estate planning webinar. Christopher and I are very excited to talk to you all about how making informed decisions and planning ahead can really help your loved ones when you're coming together with an estate plan. So before we begin, we're going to start off with a couple of disclosures. Note that this presentation is only for informational and educational purposes only. We're 3 years shy of a of a legal degree. We are not attorneys, and so before you make any kind of changes to state documents, always be sure to consult your attorney before making any of those changes. Everyone's situation is very different, and so everything that we're talking about today, just keep in mind that this is all very broad and general and not specific for any one person's situation. So just some things to keep in mind. Before we get started, you are able to ask questions. So in the top box, there's you should see a box with a question mark. You'll be able to answer questions or ask questions throughout the presentation. We're going to set aside some time at the end to answer the questions, but if it's relevant to what we're talking about in that moment, we'll go ahead and answer it. So you don't have to keep them for the end, just put your questions in throughout. And then also there is a box. It looks like it has a little paper clip. It's going to say materials. You can download the presentation in that section as well, so you can always refer to it at a future time. And so now that we got the housekeeping out of the way, let's dive in. So my name is Yesenia Realejo. I am a senior wealth advisor with Tobias Financial Advisors. I'm also our director of financial planning. I get to work very closely with a lot of our clients, helping them manage their full financial plan. And I work with our planning team, our financial planning team, who's really working behind the scenes to support advisors. Christopher?
Excellent. Thank you, Yesenia. My name is Christopher Brooks. I'm a wealth advisor here at Tobias Financial Advisors. Many of you may know my face or Yesenia's face from many of your client meetings. You've heard us speak a lot. You'll hear us speak a lot today. Please send in your questions. We want to hear your voice, even if not, physical. We want to get your questions answered.
All right, and with that, Christopher, tell everyone a little bit about Tobias.
Absolutely. So a little bit about our firm from the 30,000-foot view is we currently manage a little over $1 billion for roughly 350 clients. We have 9 CFPs on staff. We're extremely proud of our retention rate at 96%. We currently have about 26 employees, and we've been in business for 45 years, even if many of us on staff don't look that way.
So what are we talking about today? We're going to cover what is estate planning, why it's important. We're going to go in depth into each of the estate documents, both those that are important for during our lifetimes and those that really come into play after our passing. We're going to go through some case studies. I know that this can be a dry topic, not something most people want to talk about. So we're going to highlight how these documents come to life, and how does estate planning come to life in a few different case studies. So perhaps you can see yourself in one of these examples. We'll touch on some advanced estate planning techniques, go through some common mistakes, talk about how it is that we help. Like I said, we're not attorneys, so how do we get involved in the estate planning process to help our clients, and then go through a summary of key takeaways. So Christopher, walk us through, what is estate planning? What comes to mind when you hear that term?
Well, first and foremost, it's something that most people don't want to talk about. It has this connotation that it's all doom and gloom and I'm dead. That's not necessarily the case. We want to make sure to take time today to discuss the living documents as well, which are so important to make sure that your wishes are met during your lifetime, at your passing, and then ultimately beyond as well. Our goal is to minimize family conflict, preserve wealth for beneficiaries, minimize taxes and probate costs entirely if possible. And estate planning doesn't have to be correlated to your wealth. This is something that every single individual needs to be thinking of, and we'll try and touch on why that's the case today.
Excellent. And so why is estate planning important? What's the goal when we're trying to put an estate plan together in place? The first one that comes to mind is probate. Probate is the court system, or the process through which the court system disposes of your assets. Most people don't want to go through probate. This can take a lot of time and can be very expensive. Most of us don't just walk into a courtroom every single day, so you need the aid of an attorney. And so if you can plan ahead, not have to have the additional expense and time to make sure your assets get to the right place, why wouldn't we want to do that? We also want to minimize taxes. As Christopher said, we want to minimize or prevent family disputes. A lot of feelings come up after someone's passed away. So the more planning you can do, the more you can help just give guidance and clarity as to what your wishes are. We also want to make sure we're caring for minors and dependents. So it is through estate documents that you can name guardians. If something happens to you, who takes care of your children? It's also a good way to clarify what your medical and financial wishes are. There's some documents where you can name people to help make these decisions for you for financial, legal, and medical scenarios. So we'll talk a little bit about how that works. And it's really important to look at these at least every 5 years, or something in your life has changed, or even if nothing in your life has changed, laws change. And so we always want to make sure that your wishes are currently reflected in the documents that you have. Maybe you just got remarried, maybe you have an additional child, maybe grandkids are in the picture. So as your life changes, your documents should presumably change as well, or might change. And we just want to make sure that we're constantly revisiting it and making sure that your wishes are accurately reflected.
Yesenia, a quick question that came through before we jump. Can you explain a little bit, what is the cost of probate? Is it worth, spending, good hard-earned money to create these documents to avoid it? What's kind of the break even, if you'd have to say?
Absolutely. So it depends on the size of the estate, but really it could be a couple percentage. I've seen it up to 3% of the size of your estate. So the larger your estate, the larger the costs are going to be. So really, if it takes a couple thousand dollars to do these estate documents, and even if all you own is a home, which could be a couple $100,000, you're better off getting the documents in place ahead of time, because then even if it costs exactly the same, you're avoiding the headache and the time. Probate can take a couple of years to go through the court system, and so do you really want to leave your heirs going through this process, not having access to funds? Maybe grandma just passed away and we have to take care of the home, but no one has access to her accounts, right? We haven't divested the funds yet, but who's going to pay the insurance, the real estate taxes, the maintenance of this home, which is very valuable, until the assets get freed up through probate? So there's a lot of things that come to mind. So yeah, it's a very low bar for it to make sense for getting estate documents in place rather than just waiting through probate.
Excellent, thank you.
Absolutely. So Christopher, walk us through, what are some of the documents we need while we're living?
Absolutely. So while we're living, these documents are going to come into play, hopefully not too much in your day-to-day life, but they can, and that's why they're so important. They're the only ones that you actually might affect your life while living. So extremely important. We have a healthcare surrogate, a HIPAA authorization, a living will, and a durable power of attorney, which we'll go in depth in the coming slides. Excellent. So designation of healthcare surrogate. This document is known to have a couple of different names. It's really going to depend on the attorney that you're working with. It's also known as a medical power of attorney or a healthcare proxy. This document is really to outline who you want to be able to make medical decisions in the event that you are incapacitated and unable. I really want to stress unable, because they do not supersede you while you are of sound mind and able to make decisions. That's extremely important to know. As we discussed the HIPAA authorization in some coming slides, you'll find that frequently we see a lot of individuals name the same person for their HIPAA authorization as well as their healthcare surrogate. And once again, it's really good, if you can, to name someone local. If you are incapacitated in the hospital, you'd hate to have some family members having to travel across the country to help make sure that your wishes are met, and be on a plane and unable to be reached. And once again, if you can, the more people you can list within reason, the better.
Excellent. So let's talk a little bit about the HIPAA authorization. What does this do? Your protected health information is protected. Health information is not something that's allowed to be disclosed to anybody. So there's a specific document that doctors need in order to be able to share your health information. And so how can a health surrogate, let's say you're incapacitated, someone needs to make a decision regarding your healthcare. How can they make that decision if they don't have access to what's going on in the first place? Seems kind of silly, but you have to actually grant them the access in order for them to make an informed decision based on your care and what's going on. And so that's what this HIPAA authorization does. It gives the stated individuals the right to receive your protected health information and understand what's going on, what's your health situation, and the doctors are able to talk to them as though they were talking to you about your own health care. And again, as Christopher mentioned, it usually goes hand in hand with the people that you've listed in your healthcare surrogate.
So living will. This is the document that I believe evokes the most emotion in terms of the living documents. It is where we're going to outline your medical wishes and potentially end of life care, what you do or do not want. Do you want hydration to be withheld or nutrition? What about life prolonging procedures? Are you okay with being intubated or placed on a respirator? These are all questions that you should ask yourself, and you have the ability to outline. It is more than just, whether or not you want the quote unquote plug pulled. And once again, everything has to be outlined by 2 attending physicians, and your family will be consulted as well. The reason this document is so important is if you do not want, extraordinary measures to keep you alive, this needs to be outlined. Otherwise, it goes to your medical power of attorney or your next of kin, if they're able to be contacted, because doctors do have an obligation to do everything in their power to keep you alive. If that's not your wish, you want it outlined, we're going to suggest that you keep this on file with your local doctor's offices, as well as your local hospital, as it's more than likely where you could potentially end up, so that your wishes are all met.
And Christopher, I have clients who either feel very strongly or for against this document. Is this something that people need to have?
Absolutely. This is entirely optional. You can say, I don't want this. You can add it in. You can customize it with your attorney. And your wishes can be very, on a micro level and niche. For example, I know someone who's opted to be cryogenically frozen. Of course, you need to make sure everything fits with your state and local laws. You cannot supersede that, but it is, whatever you'd like, really.
So I have a client who they said they want to give, 30, 60 days for their family to come say goodbye, or they just want to make sure they're really not going to come back. Are these things that you can also add?
Absolutely. Once again, it's all going to be up to your state and local laws, but if everything is compliant, then yes, you can. And it's not uncommon that we'll see people say, I want, X amount of time. And it could be for loved ones to say goodbye, or it could be, what if, a miracle happens?
Right. Excellent. So let's shift gears a little bit. We were just talking about healthcare documents. Let's talk about the durable power of attorney. This is a very powerful document, and this is also used in your lifetime. So this is one of those lifetime documents. And what this document does is it names a person or different people who have the ability to act legally and financially on your behalf. So it's a very powerful document. That means somebody can, just as you would, access bank accounts, make payments, sign for you, as though they are you. Extremely powerful, important to have, because if, let's say you are incapacitated, you want someone to be able to step in and handle things for you. But this is really important to note. I said super really important. That's how important this is. That this is not springing. A lot of people have this document for when they are incapacitated, but you don't have to be incapacitated for this document to come into effect. So Christopher mentioned, with the healthcare documents, your healthcare surrogate cannot supersede your decision. With the durable power of attorney, they can act the moment this is signed. So it is an extremely powerful document, and you want to keep that in mind, because when you're naming people, you have to keep in mind the powers that they have. You want to make sure that you trust the individuals that you're naming. For most married couples, they'll usually name their spouse, maybe adult children or close relatives. Some people name their friends, which is totally fine. But again, you just want to make sure that there's a level of trust involved when you're naming people into these documents, but it comes in handy. And you don't have to be incapacitated. What if you're traveling overseas and you're in the middle of a real estate deal? You need someone to step in and sign a piece of paper that was forgotten. Random things come up, so it is a very important document to have.
If you don't want someone to be able to act at this time, is there anything that you can do?
Oh, yes. I love that question. A lot of our clients recognize how important this document is, but they don't necessarily want the person to have the document in their hand to just go down to the bank. So what they'll do is they'll escrow it with their attorney. And what that means is that it's going to sit at the attorney's office. You're going to want to tell the person that you've named, your power of attorney, that they are named in this document. If anything happens to you, go to the attorney and they'll be able to give them the document so that they can then act as needed. But it just creates an extra layer of protection, a little bit of a hurdle that someone has to go through just to give you some protection. That this is going to be used as intended and not going to be used by a rogue third player. I've actually seen with a client of mine where an attorney came in and tried to act on behalf of the client who was not incapacitated, asked for a loan against the accounts. I checked in with the client and he put a stop to this, but I know my client. I knew nothing was wrong with him, and I knew this was a shady request. And so, that it just goes to show how powerful this document is. You want to be able to trust the people in there. And if for some reason, not that you don't trust them, but you just want to have a little bit of extra safeguard, escrowing it with your attorney just adds that extra layer of protection. So Christopher,
Right,
who needs these documents?
Absolutely. So this is a question that we get frequently, and generally there's only one group that is thinking about these documents. That's the lower left. But we'll give a quick reasoning as to why every type of individual listed here should have these documents. So there's the young couple. They might not have much in assets yet, so the documents that are coming to follow, while still important, may not be applicable yet. But they're married, and they should be able to make decisions on each other's behalf if they choose. It's in the case of a medical emergency or otherwise. Young family, I think it goes without saying that you want to make sure that, especially once you have children, that your financial house and otherwise is in order in case of that emergency to come, to cause as little, to create as much continuity as you can for the family. The elderly couple is usually the ones that are thinking about this, and when we see these get used the most. And then last but not least, this is something I really recommend to my clients do when their kids turn 18, especially when they're going off to college. We generally, while your kids are in college, you're still paying medical costs, whether you want to or not. And God forbid something's to happen to them and they're on the other side of the country. You want to be able to make sure that you can get information as their parent and next of kin to make any decisions that are needed for their well-being.
Absolutely. And so now we're going to talk a little bit about how assets will flow at death. So we have 3 documents: the last will and testament, the separate writing memorandum, and the revocable trust. So now that we've talked about the documents that are most important while we're living, we're going to talk about the documents that come to life upon our passing and really reflect our wishes on how our assets are going to be disposed. You might also hear this termed the dispositive document for that reason. How do assets flow? So first we'll dive into the last will and testament. So if we've never heard of anything having to do with estate planning, it's likely that you've still heard of a will. Most people think of, I have my estate documents, I have a will, I've already said what I want to happen upon my passing. This is a very important document to have, but it's not the only one. So we'll go into some of the other documents that are important. But what does the last will and testament do? This document is going to do a few different functions. It's going to name your personal representative, so who is in charge of handling your affairs. If you do have a probate, who is working with the attorneys to clear out the estate, going to court, signing the documents. If you have a home, who's going to be clearing out the home and making sure all of your tangible personal property gets disposed of according to the will. You're going to name your guardian. So if you have minor children, who is going to be in charge of your children if you and or your spouse are not around. So this is a very important aspect of the will, you get to decide that rather than just letting it be up to the courts. It's going to designate how your personal property gets disposed of as well. So think of all of your furnishings, your cars, boats, pets, believe it or not, are considered tangible personal property. So all of your things, your possessions, are going to be disposed of according to the will. And these wills are usually provided with a separate writing memorandum where you can get very granular with actually where do you want each of your possessions to go and to whom. So it's a very important document to have, but the problem with the will is if you're using the will, that means you're going through probate. And we mentioned earlier, probate is timely, it takes a lot of time to go through, and it's also costly. So even people with a trust should have a will, because it does other things than just say where things, it does other items other than say where things go. So everybody should have a will. If you have a trust, it should work in tandem with your trust. But really, it is the item of last resort. If you do forget to title items in trust, it does at least say where do all of your assets go. So it's more of a catch-all, in addition to naming your guardians and saying where your personal property goes.
So the separate writing memorandum, Yesenia touched on it briefly, and we want to take a moment because this is a document that not only do we see frequently, but we hear from a lot of attorneys that we work with. This is the document that everyone forgets about. It's always provided to you because you want to go home and do this after you've left the attorney's office, because the attorney doesn't know about, grandma's tiara or the Picasso in the closet potentially. They, want you to fill it out, and it dictates, I want my engagement ring to go to my second daughter, so on and so forth. This is so important to us because we find that we build these beautiful estate plans, with the clients and with the attorneys, and it helps minimize conflict. This is great. But what about the things, whether they are of high value or just emotional value? We see that this is what creates the most argument. And it sounds like a joke, but we have heard from colleagues the stories of a tiara or the Picasso, or maybe one's collection of sports cards, whatever it may be. And you would hate to see your family fighting over these possessions when you can make it very clear and say, I want this to go to this person. Or you can even list and say, jewelry of X value to be distributed by my personal representative to my grandkids, and let them choose in a manner that doesn't cause strife.
Absolutely, and this is the thing that causes the most problems. It's very easy to split a bank account, very easy to split investments. It is not very easy to split the diamond ring or the Rolex, or even the china, or even, who knows, the teapot from your childhood that both daughters want. So it's not just the financial value, it's the sentimental, and the least amount of them having to figure it out, if possible, is going to help with reducing some contention among the family.
Absolutely.
So now let's talk about the revocable trust. A lot of you may have heard of a revocable trust, and a lot of the questions I get around this is, well, A, isn't this just for people who have a lot of wealth? Or isn't this what people do when they want to restrict or punish their kids, instead of just giving it to them outright? I love my kids. Why would I want to restrict their inheritance in any way? All very valid questions. So let's walk through what a revocable trust actually is and what it does and how it works. So a revocable trust is just an extension of you while you are living. It works exactly the same way as if you had an individual account. You just create the revocable trust of Yesenia Realejo. I am the trustee, and I am in charge of that account. I'm in charge of all of the assets in the name of the trust. And while you're living, you have full access to this. You can add to it as you like. You can remove as you like. You can also update the terms of the trust as you like while you are living. So this is not something that's just set it and forget it. This is something that may change, will likely change, as your kids get older, as your family situation changes. And so this is just a living, breathing document that says, while I'm alive, this is just mine. I'm going to use it as I see fit. And then upon my passing, it dictates how assets are going to pass to your heirs. So similar to the will, except like I said earlier, the will has to go through the court. When you have assets in a trust, you bypass the court entirely. And so now we're not going to open a probate. The trustee or the successory trustee after your passing is going to be responsible for disposing of the assets as dictated by the terms of the trust. What's nice about a trust is that you can be as flexible, as restrictive as you like. There's a lot of special terms you can put in there. What if you have a special needs child that you want to take care of and not affect their government benefits? So there's a lot of benefits to putting together a trust and being able to be selective as to how assets pass. I have a lot of clients who'll say, my situation is simple. I want it to pass to my spouse and then I want it to go to my kids. And I said, okay, do we like our kids as spouses? And they're like, oh, well, that's a different story. And so putting assets in trust for your children could be really beneficial just from an asset protection standpoint. And it doesn't have to be restrictive. You talk to your attorney about different ways of building the trust to be as flexible for your heirs or as restrictive as you want. But the point of them is that they are flexible and to be designed the way that you want them to, without the headache of going through a probate court. And you get to have a lot of benefits in how you design it for the protection of your kids.
Excellent. So how can we do some estate planning outside of just the documents? One of them is making sure that any individually titled accounts, we had a transfer on death. It could be to your trust, it could be to beneficiaries directly. Always make sure that you have some type of beneficiary. You don't want the court deciding. Jointly titled accounts, if you're a married couple, especially in Florida, there's a lot of protection provided, especially with tenants by the entirety. Real estate. Let's make sure that your real estate is titled appropriately. We make sure to work with all of our clients, once you're buttoned up with the estate planning attorney, to make sure that this is reflected in your wishes, as we don't want that to go through probate if we can. LLCs or businesses that you own. This is something, especially for our business owner clients or those who maybe have a rental property, are very near and dear to their heart. They've got a lot of time, money, blood, sweat, and tears invested into them. You'd hate for these to, once again, pass through probate. You want them to be reflective of your wishes. We can assign the LLC's interest into your revocable trust. And then last but not least, making sure that if you still maintain life insurance, that your life insurance is titled accordingly. We'll work directly with the attorney to make sure, should this life insurance be in the trust? Should it be outside of the trust? Should it have its own trust known as an ILIT? These are all things that we'll make sure are being coordinated with the attorney.
And this is really where rubber meets the road with estate planning. Estate documents are just the first step. They're so important to have, but if you don't do the work following the creation of the estate documents, then they really go by the wayside. Because if nothing is titled correctly, if you have trusts, you decided to spend the money, you saw the value, you got all these trusts, but nothing was titled in it, voila, off to probate we go. And so that's really, we want to make sure that we're not just doing half of the work. We want to make sure we're doing the full steps and making sure we're doing the follow-up, especially with hard to title assets like real estate. We actually have a client who came to us after their dad died, had spent thousands on very nice estate documents, but lo and behold, the attorney told him, he gave him a funding letter and said, here you go, fund everything in the name of your trust. And real estate, how was he going to go do that by himself? The attorneys didn't help him with it, or we don't know exactly what happened, but what we know happened was $13 million of real estate ended up having to go through probate, even though he had done all of his estate documents, because deeds weren't filed properly. And so we just want to make sure that all of the cleanup happens. If you have outside accounts, 401ks, all of our doctors who have the residency 401ks, we call them our orphan 401ks. We want to make sure we're looking at those. All possible assets, no matter how small, we want to make sure we're looking at to do the follow-up work that's involved with estate planning. And so when you're looking at your estate plan altogether, it's not just the documents, and that's what we really want to harp on. The documents are important. There is no estate plan without some level of documents, but that's not the only portion of the estate plan. And so, as Christopher mentioned, life insurance. This can be the type that we have. The life insurance beneficiaries that we've listed are going to be really important. I had a client who had done his full estate plan, never updated the beneficiary, so it only went to the son, even though there was son and daughter. Now, daughter was not, she didn't get anything because son was not obligated to share. Because if you don't update your beneficiary designations, some people don't realize this, beneficiary designations will overrule the documents. So even if you have that, I want everything split between my son and daughter in my documents. If you have one person on your account, some people will do this for their checking account. I'll just put one kid in there so it's easy for them to manage. When you pass, it's only going to go to that one kid. They're not obligated to share with the rest. So the titling in beneficiary designation is very important. The real estate deed titling, you want to make sure assets are in your trust or jointly titled. We can't do a beneficiary designation on a deed, and so we want to make sure we're speaking with attorneys to figure out the best way possible to have the home pass outside of probate. Business ownership, this gets a little bit more complicated, but business might have an LLC. You want to think about how that LLC is titled. We need to do assignments. Again, these are things that you can't just do a beneficiary designation at the bank. We'll have to talk to an attorney about. But also doing proper succession planning when it comes to your business. If you pass away, what happens to the business? You want to make sure you're having these conversations because it does get a little bit more convoluted the more different types of assets you have. And then liquid assets. These are probably the easiest to handle, just making sure you have proper titling and beneficiary designations. But all of this put together is what's going to complete your estate plan.
Excellent. So we're going to go through our first case study here. We're going to call them Jack and Sally. This is a married couple. They have 2 children. They are a blended family. So they each have a child from a previous marriage. And anytime that there's a blended family, the estate plan gets a little bit more complicated. Some families say we really just want to merge everything and everything's going to be equal. But some people came into the marriage with substantial assets from the prior marriage or on their own accord previously, and they want to make sure that that's really going to their blood heir. So in this scenario, they own 3 rental properties. They're in joint name. Sally owns a business with a few partners, and they each want to support their spouse at their passing, but want to ensure assets eventually pass to their own respective children. This is a scenario where we'll frequently see people want to do individual revocable trusts versus maybe a joint revocable trust, which, especially depending on the asset level, is more common with a lot of our clients. In terms of the businesses and some of these rental properties that are currently joint, you might want them to be owned by LLCs where each person has their specific interest assigned to their trust. Once again, it can benefit the other spouse while still living, but ultimately making sure that it flows to their respective heirs. Because as Yesenia said, we can't put the beneficiary designation on real estate. I know this is a conversation that she has a lot more commonly than I do, even as she's got a lot more clients with complicated real estate structures. And then last but not least, we really want to make sure there's succession planning for the business. What happens to this business, which for most of our business owner clients, it is commonly their largest asset. You might not see the most commas in the value on a day-to-day basis or go thinking what it's worth, but it is extremely valuable. You're investing a lot of your time into it and reinvesting proceeds into the business. So when you have these partners, especially, what happens if you were to pass away? Are we just going to expect that they're going to cut a check of your value to the family? If so, for how long? Will they get some kind of payout in perpetuity? These are all things that we want to organize with buy-sell agreements, essentially having life insurance on each other. Will their spouse step up and step into the business if qualified to do so? It's of course more difficult when we have a legal practice or a medical practice. These are all things that we want to go considering.
Absolutely. Now let's look at our second case study. We have Elsa, who is a single person. A little bit about her. She's never been married. She has a lot of friends, a lot of nieces and nephews and cousins, and she wants to help benefit them or give them gifts upon her passing. That's very important to her. But really important to note is that those people can change relatively frequently, every couple of years. she wanted to donate to charity during her lifetime, but also upon her passing. And because she's not married, because she doesn't have children, she's particularly concerned with planning for her elder years. So in order to solve some of these things that she came with us, the first one we touched on was, all right, every single time you change your beneficiaries, who you want to give individual gifts to, you're calling up your attorney and you're making a very expensive change. Again, you should make these changes as you need to. Don't let the cost deter you from making much needed changes. But if there's a better way to do it, let's do that. And so for this, where she just wanted $10,000, $5,000, maybe $1,000 going out to 15 people, we actually just created a separate account in her name, and that's her individual gifts account. It's going outside of her trust, but we have named all of her beneficiaries on there. So it'll still avoid probate. They're still going to get the amounts that she's looking to have, but it's free to change a beneficiary designation. And for such small changes like this, we thought it was just a lot more efficient. And we also wouldn't want her to not make the changes that she wants to because it costs extra to go to the attorney. So this really helps solve that problem for her. And she does have a revocable trust for all of her other assets. She did have a nephew that she wanted assets to go to in trust. So it was important for her to have that because, again, she didn't have joint titling. Because she's not married, it's not her real estate, her accounts aren't just going to automatically pass to one other individual. But particularly with the real estate, it was important for her to have a revocable trust to avoid probate on her home. We also talked to her about donor advised funds. She wanted to donate to charity in her life and also in her passing. So we talked to her about how best to fund the donor advised fund in her passing. We talked to her about what are the best assets to donate to charity. She had a substantial IRA, and some people were talking to her about doing Roth conversions, and we said, hey, why would we do Roth conversions when this is going to go to charity anyway? And instead, let's just have your trust assets go to your heirs. That way, nobody has to pay income tax on that IRA. So depending on what your goals are, especially if charity is involved, we want to have a conversation about how best to fulfill those goals. Because I usually see a lot of people put in their will or their trust that they want to do donations to charity, but what if they have pre-tax assets that would be a much more tax efficient way of fulfilling those goals? We want to make sure we have those conversations. And as far as planning for the elder years, she doesn't have a spouse, she doesn't have older children that would automatically step in to take care of her, and she just wanted to plan ahead. And so she actually worked with an attorney to establish a pre-need guardian. This is a document, we don't see it as frequently, but it's a document where you can name who's going to step in and be my guardian if I'm incompetent and unable to handle my affairs. So this was her just really thinking ahead and trying to be proactive.
Excellent. So here's our third case study. We have Moana. She is a recently divorced mom with minor children. She has a joint trust with her previous spouse, and she's concerned about the influence her prior spouse has on the children upon passing. So there's a lot to unpack here. First and foremost, it's not uncommon that even if a divorce happened many years ago, that we'll see people still have an estate plan that was once joint, and you might have a beautiful relationship with your ex, and we hope that's the case, and get along with each other very well. But we do think it's a good thing to do once the divorce is closed. Let's revisit the estate plan. Let's see, do we still want your former spouse as a power of attorney, so on and so forth, trustee. And in the case of Moana, we made the recommendation to go to an individual irrevocable trust. We included new decision makers through trustees as well as in the living documents, because she wanted to move on, turn the new leaf and start kind of her new life. It does not mean that the former spouse won't have influence on the kids in other ways, but it is an important one. Make sure the life insurance beneficiary is updated. I can't tell you how many times I've seen that, someone's on the second marriage. We're 12 years in. We're doing a life insurance beneficiary review, and I never enjoy giving the news, hey, your prior wife or prior husband is still the beneficiary. It's incentive to make sure that you're still alive, but let's get that changed. Let's get it reflected in the new documents. And in this scenario, there was a separate account set up in terms of alimony. Moana was paying alimony, and she really didn't like seeing that go out. So we diverted a portion of income directly to a separate account. So it's kind of out of sight, out of mind. Once again, in this scenario, she wanted separation. She wanted to really turn a new leaf and start over, and we can help facilitate that through the estate plan.
And now let's look at our last case study, Andy. This is an adult child who is off to college. He's 18 years old, starting college after the summer. College is out of state, so now you're going to be empty nesters. And the parents are very concerned with the lack of information. Christopher had mentioned this earlier. Once the child goes off to college, if he gets into an accident, he's an adult. The hospital is not obligated to share any of the health information. Again, the protected health information. Once you're an adult, you are cut off. It doesn't matter that you're still paying 100% of your kid's bills. They don't care about that. And so how do we fix this? Because yes, even though they're technically adults, a lot of college age students are still very heavily dependent on mom and dad. And so what you can do is actually create some of these lifetime documents for your 18-year-old, 19, 20, 21, doesn't matter, once they're over 18. And that's going to include a healthcare surrogate, the HIPAA authorization, and a durable power of attorney. Maybe they don't need a will at this time. Maybe they're too young to really make a decision on a living will, but these are the 3 documents that we generally recommend so that parents still have the ability to help their children if they end up in a pickle, if they need to figure out what's going on. I've heard horror stories where one of my clients told me that daughter was unconscious, it was in the hospital, and they were saying, we need to take her ovary, and they wouldn't tell her why. And she just had to drive up to Gainesville and had to stop it. She had to be there in person for them to actually share any information, and she was able to stop it. It was completely unnecessary. But yeah, there's just horror stories where parents are unable to act because they don't have these documents in place for their still very dependent adult children.
Absolutely. A good reminder for them in my own instance, once that adult child eventually goes and gets married, you will want to remind them to update these documents. Just because you have a spouse does not supersede the documents. Like I said, my own personal experience there, and shameless plug to go and update the documents once you've entered the next phase of life.
Definitely. We don't want Christopher's wife fighting with his mom over what to do.
Excellent. So planning strategies for taxable estates. We're going to spend a little bit less time going over this because it's less applicable to the masses, but make sure to speak in depth with your client, with your advisors and your attorneys if this is applicable to you. We spend a lot of time, on this, and I'd say we're dangerous at it. But the one big beautiful bill passed recently in 2025. Starting in 2026, the estate tax exemption is theoretically not going to lower. It is made permanent at $15 million per person, indexed for inflation. So if you're a married couple, that means you can have $30 million before the government's going to tax your estate at 40% on additional assets to your heirs. What does that mean? We need to get creative in our planning solutions to try and minimize estate tax. You've worked really hard. You've paid a lot in tax. Let's try and pass as much as we can in a tax advantaged manner. A couple of things that we can consider is using annual exclusion gifts. This year, that is $19,000 per person that you can give. So if it's a married couple, it's $38,000. There is no limit as to how many people you can give exclusion gifts to. Generally, people were seeing it given to family members or someone very close. You're not just going to walk down the street and start handing out large amounts of money. We can utilize an irrevocable life insurance trust, which we discussed earlier. That can be, once again, a planning tool for assets for your next generation, or it can be a planning tool to use life insurance proceeds to pay an estate tax bill so that real estate or businesses may not have to be sold. We have the ability to fund 529 plans for children and grandchildren. This is my personal favorite estate tax mitigation tool, and largely why I got into wealth management. We can make gifts to these to use for education. They pass estate tax free. So a great tool if you believe in education. There's what's known as a spousal lifetime access trust, or a SLAT. We like our analogies, as do attorneys. This is a more complicated structure where you're giving to your spouse irrevocably. There is an element of access during your lifetime. If possible, we want to not use that. We're more than happy to speak with you on an individual case-by-case basis. And then ultimately, we can transfer businesses to the next generation utilizing discounts. We get a valuation done of your business. It might take a discount for lack of marketability, lack of control, so on and so forth. And we can gift that interest either directly to the next generation or into one of these trusts listed here, or many others with all kinds of crazy abbreviations. Last but not least is one that's really popular with our clients. We have a great client base that's extremely charitable. And if charitable giving is a part of your plan, let's discuss, as Yesenia said, we want to make sure, what assets are we giving to charity? Can we do it in a way that is going to minimize taxes? Because no matter what, the charity doesn't pay taxes if they're an official 501c3, but your heirs will. So let's maximize their benefit. Let's maximize your heirs' benefit while doing a lot of good with your assets.
Absolutely. Actually, on that end, I have a client who, if you just look at the net worth, would fall into this taxable estate situation, but they said, my two boys, it's going to be enough. So they're each going to get a third, and then a third of my estate is going to go to charity. So because of that, charity actually it reduces your taxable estate. And so that's a great planning opportunity when you want to reduce your taxable estate. So there's a lot of different creative ways we can go about it. And we absolutely love helping our clients, especially when it comes to their charitable giving.
And if I may, really quick, one thing with a lot of these more complex trusts, especially in the social media age, we're having a lot of conversations from clients that they saw something on TikTok or Instagram. And I never want to shoot down an idea just because you saw it on Instagram. In many cases, it's actually a valid planning technique. But the implementation that's discussed, I've seen in many cases that it was right for a specific person, maybe not you. In some cases, the advice on the internet is not necessarily correct, and I have seen it quite literally be illegal. Bring these conversations up to us. We always welcome them and enjoy them, but take what you're saying on the internet as a grain of salt. Speak with your estate planning attorney and speak with your financial planners.
Yeah, a lot of people, when they do these videos on TikTok, don't give the same disclaimer that they're not attorneys. So let's talk about some of the common mistakes that we see happen. The first one is just not having a plan, not having put any documents together. Maybe they put documents in place, but they didn't do the follow-up of making sure retitling and beneficiary designations got done. Maybe you do have documents, but they're from the 1990s. And even if nothing in your life has changed, you want it exactly to pass the way your documents have stated, it's really important to note that laws change over time. Even from a couple of years ago, the healthcare surrogates that we see now are vastly different, because at least in Florida, there's been different changes regarding what powers and what different conditions you have to sign off on ahead of time or in the living will, in order for them to be available to even be a decision that you can make. Tax laws have changed vastly. I mean, I know before 2017, the tax law hadn't changed since the 1980s, but since I've been working at Tobias, it's changed several times. So we've had various tax law changes happen in the last couple of years, and even if those are the paragraphs that you're really reading on those estate documents, they do matter. So even if nothing else changes, you want to make sure that all of the language in the documents are brought up to date to reflect what's actually happening today. Incorrect beneficiary designations, Christopher touched on this. Having the ex-spouse listed, maybe you put one kid because you said he'll pay off the mortgage and then split it with his sister. He probably won't. Or she probably wouldn't, right? That's just, when you're not legally obligated to do something after somebody passes, it's less likely for them to do the thing out of the goodness of their own heart. And we just see it time and time again. So just making sure that your wishes are properly reflected, not funding your trust, the TikTok DIY without guidance. There's so many different resources out there, a lot of really good information out there. what I think we have to step back and realize is that not every planning idea is right or applicable for every single person. It really depends on your situation, what you have going on, what are your goals. And so understanding that there's a lot of different ways to go about it, but we want to talk with professionals, with your financial planner, with your estate planning attorney, in making sure that the strategies you're implementing are actually right for you and understanding the implications of them. And forgetting about assets and bank accounts. I see this all the time. Clients think it's annoying when we're going through our very big list. Okay, what else do you have? And they'll look at me a little side-eyed. I'm like, I'm not asking because I want to manage it. I just want to know that you have a beneficiary designation on there. Don't even tell me how much is in there. We just want to make sure that your assets are titled appropriately, that you don't have gold bars hiding in your house that A, is not insured and we don't know what's going to happen upon your passing. You don't have money buried in the backyard. Oh, I forgot about this vacation home in this other state, right? Now you have a different probate exposure because you have an asset in a different state. And so just you want to make sure that you're aware of all of the different assets you have and titling them appropriately.
Excellent. So how do we help? Ultimately, we are extremely collaborative with attorneys. I think we've made it very clear, or hope to at least, that we are not attorneys. We want to try and help connect you with the right attorney for you. Just because they're an estate planning attorney doesn't mean they might be the right one for you. Just like you want to find the right advisor. So let us help you find them. We'll work as a team to make sure everything is actually implemented correctly. We're going to create a visual flow of your estate, especially as the estate gets more complicated. I have one client in particular who thinks it's really simple, and there was, over 60 accounts. And it made sense to him, but we needed to flow it out and we need to make sense of it. We're going to review your documents from a planning perspective every couple of years. Make sure that it's still meeting your wishes, and we will keep in contact with our attorneys, the friends, and making sure, okay, what changes in law have happened? Do we need to update any documents for certain reasons? We're going to keep tracking your net worth, especially if you're getting closer to these numbers where you might be in a taxable estate, because there's a lot of planning work that needs to go into that. Of course, most of our clients know just about every single meeting we're making sure that titling and beneficiaries are correct, and then ultimately ongoing plan maintenance. Just like your financial plan, an estate plan is not a set it and forget it item. It's one that constantly needs to be massaged.
So some key takeaways that we want to make sure that everybody walks away with today. Estate planning is important for everyone. At the end of the day, we do this because A, it's going to help our loved ones, and it's going to help them save time, money, frustration. It's ideally going to help them with any kind of potential disputes between family members. Ultimately, love is at the core of this. You want to plan for your family members to make it easier for them upon your passing. They're already dealing with the devastation of your passing. Why not make it a little bit easier for them to handle all of the administrative items that come along with it? We want to make sure you understand the roles in each document and what they do, because really that's going to inform who is the best person in each of these roles. We have some clients they'll just go in birth order. I'll go in birth order of my adult children, and then I'll have others that say, no, for the healthcare documents, I want my nurse and doctor to be the first people listed, and then I want my attorney or my CPA son or daughter to be the person listed on the durable power of attorney. And so understanding the roles are going to help you make the best decision as to who should be named in there. And estate planning isn't just the documents. It's making sure that you know all of your assets, how they're titled, what are the beneficiary designations, in addition to having the documents in place. And it's very important that you consider your unique circumstances and talk with your advisors, talk with your attorneys to make sure that the strategies you're putting in place are right for you. And also, if you do have a need for more complex estate planning, be sure to talk with your advisors on that. There's a lot of different strategies if you have a taxable estate. And again, making sure that any strategies proposed are going to be the ones that are right for you. And so
we open it for any questions.
Yes, and we did have one come through that I'd love to answer. I think it's a great one. It is regarding a power of attorney. So this is the document where someone can act in your financial or legal shoes. The question is it recommended to have an internal power of attorney provided by the financial institution executed in addition to the general durable power of attorney? I think this is a fabulous question because banks and custodians are notorious for not wanting to accept the general durable power of attorney that is written up by attorneys. The reason for it is that there's a lot of liability in this, right? Someone is acting on behalf of another person with their money. This is a huge power. And so some financial institutions, or most of them, actually have their own power of attorney that they want to have clients sign in addition to the third party one created by an attorney. It's generally recommended that's going to be the easiest way for it to be accepted. In my experience, you have to fight with the custodian, and they will accept the third party power of attorney drafted by the attorneys. So it's not like those documents won't be in effect even if you get them done. It just creates a little bit more of a headache when you have to go down the route of fighting with the custodian. Will generally be accepted, but most of them do offer their own power of attorney to have on file as well. So great question, love that. All right, and I think I see another one coming in here too. I have a trust for kids already listed in my will. Does this mean it's going to avoid probate? So Christopher, you want to take that one?
So the answer here is this is a trust that will ultimately be created through your will. And as we said, assets that flow through the will are going to go through probate. This is what's known as a testamentary trust. If possible, we think it's definitely worth revisiting and updating to create the living trust now. Make sure it's all funded. And then that will can still kind of act as the catch-all for those outside assets. But we want to make sure that we can pass everything as quickly and smoothly as possible. If there, ideally we have no probate. If there is, we'd rather it be some straggling assets than the bulk of them going through.
Excellent. And then do you see any other questions coming through?
All set on my end.
All right. So that is everything we had for you. Thank you so much for joining us today. We hope this was educational. You took a nugget or two. Perhaps some strategies or items that you could think about updating for yourself or for your family members. And of course, if you have any questions, we are here to help, and please don't hesitate to reach out. Thank you so much, and hope you guys have a lovely day.
Thank you all for your time.